Okay, welcome to the April Oldham County Board of Adjustments and Appeals. My name is Larry Outerback. It's a little bit after 9 o'clock and we are now in session. We have two cases today, both of which the procedures will be the same. Here in a minute, I'm going to swear staff in. They will come to the podium and give us a staff report. Gretchen's going to read the case. Staff's going to give us the staff report. There'll be a round of questioning by board members to staff. And when we're done with that, staff's going to take a seat. And then I will call you, the applicant, forward. You need to come forward. Please speak directly into the mic. Things are being recorded and cameras and whatnot, so you have to be up here at the podium to speak. But you come up here, justify your case. When we're done with that, there'll be a round of questioning by board members to you, the applicant. And when we're done, you may take a seat. I'll call forward anybody that wishes to speak in favor of the application and then opposed to the application. Same thing. You're going to come forward, speak into the mic. You're going to get sworn in. Raise your right hand, get sworn in, state your name and address, and tell us why you're in favor. Tell us why you're opposed. Round of questioning. When you're done, you may take a seat. There'll be a time for rebuttals, final statements, any final questioning by board members to anybody, and then I'm going to close the floor, open it up for discussion, and take an up and down vote. Okay. Please make sure cell phones are off. If you need to use it, please excuse yourself from the courtroom and just make sure it's off when you come back in. Board members, same for you, and please make sure your mics are on. And let's go ahead and swear staff in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
And Gretchen, if you'd like to read the first one, please.
OC 23-010, an application has been filed for the removal of a previously issued conditional use permit, OC 18-015, at a property located at 4610 North Camden Lane, Crestwood.
Thank you. Ryan Fisher, Senior Planner with Oldham County Planning and Development, 100 West Jefferson. So before you today with a revision or removal of a conditional use permit, a previously issued one for 4610 North Camden Lane. So as Ms. Chipwood stated, an application has been filed for the removal of a previously issued conditional use permit, which was OC 18015, at a property located at 4610 North Camden. So here is our site information. It is R2 residential. It sits on 2.23 acres. So a little bit of the site history. So on April 19th, 2018, the Oldham County Board of Adjustments approved a conditional use permit, that OC 18015 I referenced earlier, allowing an 1,800 square foot accessory dwelling unit. So it has 900 square foot of living space, 900 square foot of garage space, to be constructed prior to the construction of a primary residence. And that motion passed 4-0. So as you will see, as we kind of go along with this case, that house was never constructed. Ownership has now been transferred to another party. And so here we are today kind of looking at what the applicants now can do with this conditional use that's on the property. So a little bit of the case history. So this was originally scheduled to come before you all in March. It was tabled. So as you'll see there, the APOs went out for the March hearing, public notice appeared, and then that project was requested to be tabled until this April meeting. That was on March 15th. And so we reposted those agendas to our county website on the 29th of March. New adjoining property owner notices went out for that April hearing on the 6th of April. And the public notice appeared in the Oldham area again on the 13th of April. So here is the property on North Camden Lane. As you can see, here is the previously constructed accessory dwelling unit. Here is your zoning map showing it's in an R2 area. So the applicant is requesting a conditional use permit be removed from the parcel and the already constructed dwelling be considered the primary residence. Now I will say the applicants came in several months ago, talked to us about different options that they could do. And as we go through this case, I'll explain why there's certain options that really aren't, and they'll be able to explain as well why they came to the conclusion of the option that they've picked today. So section 250-030, those accessory uses and structures, states it shall follow the principal use. And if not, then they come before this board for a conditional use permit, which is what was granted back in 2018, that he could have that constructed. So that current accessory dwelling unit, as I stated, is 1,800 square feet. It's 30 by 60. So 900 square feet of that is used for living space, and 900 square feet is used as a garage. That accessory dwelling unit had all the necessary permits and inspections. You can see the permit there on the right side of your screen. It was also included in your staff packet, as well as the certificate of occupancy that was granted on January 17, 2019 for that structure, that accessory dwelling unit. So section 250-040E number 5 states that those detached accessory dwelling units shall not exceed 25% of the primary structure square footage. So in order to comply with this regulation, the applicants today would have to construct at least a 3,600 square foot home. They will probably explain to you today, and I'll let them explain to you why that's maybe not feasible for them, or what they really want a house that big. The original applicant had plans for a 4,200 square foot home, which complied, with their accessory dwelling regulation. The applicant in the original case did state that they had planned to build a home on the property within the next 2 to 3 years, give them an option to have their aging parents on the property, no intentions of renting that ADU out, and would be designed and constructed to match the future home and allow the applicant to better support the building of the new home financially while having a place to stay close by with the project. No conditions of approval or binding elements that required that primary residence, though, to be built within a certain time frame within that original case. So here is, once again, the property. You see the lateral field here, the septic lines in the rear of the property. This area here is where the original applicant intended to build the house, and you can see the plans that were provided with that original case showing the detached accessory dwelling unit, which complied with all the setback regulations and everything at the time, and then where the primary structure was going to be on that property. Here are the floor plans of what the applicants are in now, considered the ADU, with the living space on the right side and the garage. And on the pictures, it'll come to life for you. Here is a floor plan. All of these were also included in your staff packet. 2 bedrooms in the rear, bathroom. There's a living room area here and kitchen to the left as soon as you come in the front door. And here is the structure on pictures I took while I was on the property. So the living space here on the right side, door goes straight into the living area, kitchen space over here, and this is all the garage space to the left. Bedrooms are in the rear. Here's a picture looking down the driveway towards North Camden Lane, and a picture looking back up the driveway at the structure and what it appears to be from the roadway. So in summary, the applicant's requesting to revise or really remove that existing conditional use permit to allow the 1,800 square foot structure that's on the property with that 900 square feet of living space to be considered the primary structure instead of an accessory dwelling unit. So the conditional use permit, the change to it shall only apply to the plan considered at the April 20th, 2023 Oldham County Board of Adjustments public hearing. And that is all I have. You all have any questions? I'd be more than happy to entertain them. I'm sure you will.
Any questions?
On the slide, where the initial owners were going to build their house, is that still going to be the plan and of where a new structure would be built?
So I'll let the applicants address that. In conversations that we had, it's the applicant's intent. They have a son who they would like to kind of keep on the property. And so their thought is maybe to build him an ADU, or, and have them build their primary house and have him stay in what's currently the ADU. But the size restriction is really what's kind of limiting them. They don't really want financially to build a 3,600 square foot home for them. But then if you keep this the primary dwelling and they go to build an ADU, you're limited to 250 square feet. So, but they'll be able to tell you more of why they came to that solution. But really it came down to the maximum square footage was kind of limiting on both sides for them.
So the ADU that was approved in 18, did you say, were there any conditions set?
I don't know if I copied the conditions of approval on I think it's on the back of your staff packet. If I can recall, I put it. Yeah, so the findings and decisions of OC 1815 are on page 3 and shall only apply to the plan considered at the April 19th, 2018 Board of Adjustments public hearing.
All right. Any other questions for Ryan? All right, thanks. If we can have the applicant come forward. Good morning. I need to get you sworn in and state your name and address, please.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Address?
T. Edwards, 4610 North Camden Lane, Crestwood.
Kelsey Edwards, 4610 North Camden Lane.
Okay, and if you can justify the project, tell us what it is you're trying to do.
We're just trying to change it into primary dwelling to get this amended, because we're not ready to build yet. We have a lot, we're still in the planning. It's probably going to be, 4 to 5 years before we ever build. And the size restriction, we were only thinking about building about 1,000 square foot house to house our one son to keep on the property. So the 3,600 is that's a big difference. So do you have anything to add?
Just to reiterate what Kelsey was saying, we really just wanted to build something smaller. We don't financially have the ability to build something that large, nor is it really needed for our situation with the kiddo. So we're not capable at this point of being able to do that. So that is why we would like to have this changed to the primary.
Okay. Any questions for Stacy or Kelsey? So is it your intent then you're going to make this the primary structure, and then at what point it is your intent to build a secondary ADU, correct? And when?
Exactly. We've looked at different plans. We've looked at the property as a whole to try to determine, where is the best location and how everything would work. So it's really just a matter of planning and having our ducks in a row and being able to be financially able to do that. So ideally, our child is 14 at this point. So when he reached 18, I'd like to be able to have him in his own place. He is on the autism spectrum, and we'd like to be able to supervise and guide and help him, but him also be able to have his own place.
Okay. Any questions for the applicants?
Background, how long have you owned this property? How long have you owned this property? And were you aware of the restriction when you bought the property?
That there was a conditional use permit, so we did not know the 25% rule.
Okay.
So we were under the impression that we were okay, we had time, everything was going to work out, and then when we found out about the 25%, that changed everything.
Okay. Thank you.
I'm still a little confused on exactly what you're going to do. Are you going to take the garage doors out of there and make that the primary living space?
I'm sorry, it cut out just a little bit.
So right now there's 2 garage doors. It looks like big garage doors there next to the living space. All right, and you're going to convert that area to additional living space in the building?
Not intend to convert that to additional living space. We would build the new house across, or the area that they pointed out earlier is where we would intend to build.
Got it.
So the only thing that's before us today is removal of the CUP. All right, any other questions for the applicants?
Well, the removal of the CUP doesn't, there are no neighborhood type of restrictions for square footage that we're dealing with today, right? This is just a removal of the CUP.
Removal of the CUP.
And nothing else.
Right. I'm going to call staff back up here in a second, but any other questions for the applicant? Okay, thank you. Is there anybody here wishing to speak in favor? Ryan, did we have any emails, phone calls, anything?
Just share this one. I did receive it this morning, so pardon me, I haven't really had a chance to read it. I will put it up on the screen. Do you still do that with our new technology?
Jay, how do we put something on the overhead? It's switching.
So hopefully you all can read that as a
It's good.
letter in support. Get it out loud.
Go ahead. You can.
Says is, we are writing this letter in response to a notice we received from the Board of Adjustments and Appeals regarding the property at 4610 North Camden Lane, docket OC 23010. We are a direct adjoining property owner located at 4600 North Camden. The Edwards family are our next door neighbors. They requested that the current conditional use permit be amended to make their accessory dwelling unit their primary residence. We are 100% in full support of their request. We have visited with the Edwards family in their home numerous times. It is a lovely home. We have also spent many times in the home with the previous owners, a family of 4 whom occupied the home for 4 years. We shared great memories in their home for family friend gatherings, birthday parties, dinners, etc. This is a beautiful family home, and we look forward to creating many more memories with Stacy, Kelsey, and Luke Edwards. There is absolutely no reason why the board should not grant the requested amendment to make their accessory dwelling their primary residence. Simply put, this is a home with an attached 2-car garage. In fact, this home was built in the popular barn-dominium style. It has great curb appeal, is pleasing to the eye, and is always well kept. It is a pleasure to live directly next door. We are greatly concerned as to why the BOA did not address this with the previous owners who occupied the dwelling for 4 years, but are now addressing it with Stacy and Kelsey Edwards and their young son Luke within the first year of occupying the property. They are still settling in and have barely had time to enjoy their home. Why now? It has come to our attention that a surrounding neighbor or two have brought up concerns with the current conditional use, which has led us to this day. It doesn't make sense to us because they are not on adjoining properties as we are. In fact, those that may have made concerns are located on an access road off of North Camden Lane. Some do not even have a view of 4610 North Camden Lane from their property. In our view, their opinion is irrelevant. Please grant the Edwards request to amend the current CUP to allow the accessory dwelling to become their primary residence. This will allow the Edwards family to enjoy their new family home peacefully. Kind regards, Greg Lichteg, hopefully I didn't mess up that name, and Courtney Prusill, 4600 North Camden Lane. Apologize for the names.
Thank you. Okay. Was there other people that wish to speak in favor of the application? Come forward. And swear in, state your name and address, yeah.
Snack, 4100 Myers Avenue, Crestwood, Kentucky.
I'm sorry, that was Corey. And let's get sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
I am the previous owner for this property, so I'm here speaking on behalf in favor of approving this to become the primary structure. One point being, during the first hearing, one point made under the findings and decisions, the accessory dwelling unit can stand on its own and could have been approved without coming to this board. It is not in conflict with the elements, objectives, and policies of the comprehensive plan. So our original plan was to divide the property, build this, and then build the primary structure on a separate parcel. But after talking to staff, they convinced me to do this method because it was significantly cheaper. So you really have a few options. You can allow them to build a smaller primary structure on under the same permit, which is not what they're requesting. Or, I mean, because the structure that stands there, if people don't like the way it looks, that's unfortunate because it's permitted. You can build that. You could tear it down and build this exact same structure back in its place because it follows all the elements and objectives of the comprehensive plan. So I think it's really a simple case that you should move forward and allow it to be the primary. Other point being, they plan to build a primary structure. They could remove the bedrooms from the garage and just make it an accessory dwelling or accessory structure instead of a dwelling unit. That way, they could still be there. They could build whatever size they wanted to as an option. But that's not what they're looking for today. So I guess at this point, they'll have to come back before the board for approval to build a primary structure. Is that correct?
An ADU, an accessory.
Build a primary structure if they wanted to build another house. Because if they built another ADU, it would be 25% of that structure.
Right.
And I don't think the neighbors that are not in favor of this, they want to see a house built. they're not really concerned with there being just that. They want a house. They want to see a house. I sure understand that, but that was the complaint from what I understand. So, and I'm welcome to answer any questions.
Questions for Corey? All right, thank you, Corey. All right, anybody else wishing to speak in favor? Opposed? Board members, questions for anybody? Final statements? Yeah. Okay.
Order. And I'll just read this one to you as well. So we did receive one phone call prior to the March hearing that was a very extensive spirited phone call in opposition, and then received a letter on the 8th of March for the occupants of 4571 North Camden Lane, who said the lot located at 4610 North Camden Lane is supposed to be a residential land with a house. Previous owners had an agreement tied to the lot allowing them to build their barn and garage accessory dwelling with a house shortly afterwards. It is very unfortunate the current owners are stating they can't fulfill the primary dwelling requirements set forth when they purchased the property from the previous owners. If that is the case, the property should have never been purchased in the first place, as that was the agreed upon amendment to the lot and should be enforced. The Planning and Development Department exists for a reason. Agreements, amendments, contracts, rules, etc. are to be upheld and enforced. Consistency is key. It is the original agreement. If the original agreement can't be fulfilled, then the next step should be for the current owners to request approval to build a smaller house. It is not reasonable for the owners to consider a barn, garage, accessory dwelling a residence. And that is from Melissa and Jeremy Lilly.
Thank you. Okay. Stacy, Kelsey, any final statements?
Just trying to be in compliance. From the very beginning of purchasing this property, that was our intent. We wanted to do whatever was the right way. We were not fully educated on what that was at the time, and we tried to learn to do whatever was right for the property. Our intent is to build in the future, but not at this exact time. So based off all of the information that we have been given, this seems like the best decision for us to make it primary.
Okay.
Yeah, because we cannot fulfill the 3,600 square foot requirement.
Okay. All right. Thank you, guys. Brian, I've got a question for you. If you can come forward, please. So there have been several cases come before us where the conditional use permit is being revoked. It's being taken away for several different reasons. I think this might be the first that I've seen where somebody's come before us to tell us they don't want it anymore, which is a little unusual. Is this the only method of not revoking, but turning in this a permit, the CUP, saying I don't want this anymore?
So, like I said, they came in and met with us probably 2 or 3 times maybe before they decided on this course of action. We looked at several different options. I mean, it's obviously 2.23 acres, so they could split the lot into 2. That was an option that we looked at with them, is to do a minor plat process to be able to create an acre tract each. Some of the problems being the septic field that they created when it was installed, and you can maybe ask Corey if you have any questions. That was large enough to have the 4,200 square foot home. I don't remember the amount of bedrooms that was in addition to the ADU. So if that was going to be the case, they were going to have to go through, create a septic easement and things like that to try to create that to be able to be used for both lots. In addition to, they talked about their son, they'd like to have him on the property, to have his own house. Looked at the square footage. They talked about wanting to build a primary home, but that's when we just started talking about the square footage limitation of they would have to at least build a 3,600 square foot home, or they'd be back in here again with you all asking for a square footage variance. And then in addition, if they make this the primary home, which they want to do, if they go to build an ADU over here, it's limited to 220 25 square feet because of the 25% rule. So they'd be back in here again. So really, we just looked at a lot of different options. And that at the time, like they've stated, that this one kind of makes the most financial sense for them. So that's kind of where we're at. So yeah, to my knowledge, I haven't been here that long, but Jim, I don't know if he remembers another case to where somebody asked for one to be removed, but definitely in my short time here, this is the first one I.
All right. Any questions for anybody?
If we approve this and we revoke the permission, do they have to come back to build another structure in any case?
Or an ADU, they would.
Or an ADU, they would. Now, what they could do is if they split, you want to.
Yeah, regardless of this parcel, if it's going to be a principal structure, but they don't want to do 4,000 square feet, they would have to get a waiver from, or that requirement.
It's for that.
If they were going to do an ADU and it was going to be greater than 250 square feet, then they would have to get a variance. So and part of the difficulty was they didn't know what they wanted to do at this point. They wanted to just be able to kind of clear this up. So the bottom line is, unless they divide the property in half, they will be back here if they're going to build another building on this one parcel.
They're doing this in anticipation of in the future sometime doing something else, and they don't want this anymore.
It's kind of cleaning the slate, if you will. And again, as been stated, if they had just this parcel and they came in for a single-family building permit for this exact building, we would have permitted it with no other agency involved, because houses like this are permitted. So they just want to wipe the slate clean and then decide what they want to do in the future, and then they'll come back to us, and either they'll appear here again if it's going to be on the same parcel, or they'll divide the parcel in half, get the cross-access easement for the septic system, and build a house separately.
Okay, thank you.
This is, Jim, this is the only method of turning in or reversing a CUP. Think of all the other different types of CUPs we've had. If somebody decides they don't want to do it anymore, an event space. I don't want to do an event space anymore. Do they have to come here to get it revoked? And if we deny it?
In a case of an event space, if they don't want to do it anymore, they just stop doing it.
Yeah.
However, the ability to do an event space stays with the land.
It's still there. That's right.
It's different. This one is really unique in that what they're trying to do, there was not a binding element that said that the main structure had to be, the principal structure had to be built within a certain time frame. We heard testimony during that hearing of a couple of years. Those couple of years have expired. The original applicant has actually moved on. So they just want to start fresh. It's different than we've ever seen before.
It is.
If there was a binding element that said they had to build the house within X years and it was approaching that, that would be one that you would have seen before, amendment to an existing binding element. Or condition of approval, sorry, using the wrong term. We've seen those occasionally. They want to change the hours of operation on something or whatever. We don't see them very often. This is unique.
Yeah, really.
Bottom line for me is that if this were just a parcel of land where someone was building this exact structure, there is nothing outside of compliance if this building was built today on that property without any indication of building another property on it or an ADU or anything else. If it was being built today, it would be completely within compliance.
Been permitted as a single family structure,
Would not have involved any other issues. That should address the opposition, that had opposition, that this is not a structure that needed any type of special consideration if it were being built today.
What the opposition has stated, I'm not sure it satisfies them because there was an anticipation there was going to be a larger, not sure it satisfies them because there was an anticipation there was going to be a larger house on the property as well.
Okay.
So the consequence of approving this is simply this becomes the primary structure now. That's what an approval means. The consequence of denying this means that the residence stays exactly as it is. It is an ADU, and further development They either have to build a primary residence at that point, which has to be the 3,600, or get a variance, or they do another ADU, two ADUs on it. So that's the consequence of denying this.
Yes, what's in my head is that if you were to consider denying it, I think you would place a condition that says you have to build the principal structure within a certain amount of time. If they didn't, then we'd get into code enforcement action or something. So that's really the consequence, is forcing something to happen that may not be desirable to the current owner.
Isn't another alternative for them to subdivide it?
We were talking about.
Right.
Ryan described the options that we had, and they can still do that in the future.
Right, okay.
So again, if you were to allow this to happen today, then the options they have are do nothing. They can just leave this as it is. They live there for as long as they want. They do no additional building. If they wanted to put another structure on the same parcel, one parcel, it obviously would not comply with the size limitations, either for a principal structure or a accessory structure, because the accessory would be too small, the principal would be too big. So they'd come back here. That's option 2. Do nothing, come back here, or do a minor plat and divide the property, and there's enough room to do that, and then they could build another single family on that other parcel.
Whatever size they wanted.
Yeah.
Yeah, okay.
Does a minor plat, does that do anything to to an established CUP? CUP runs with the land. So
In this case, I don't believe it changes the CUP.
all right.
Changes is your previous, that's why they're here. It changes this original decision.
All right, questions? Okay, thank you, guys. Board members, before I close the floor, questions for anybody else? All right, I'm going to close the floor, open it up for general discussion.
I think the only concern that was brought up from the opposition was that, the only concern that was brought up from the opposition was that they had an idea of what was going to happen to this property, but there's no real obligation for that to be the case. Since the property has transferred ownership, there's no reasonable expectation of there being a 4,000 square foot house there, and they're under no obligation to build that. And down the road, that is something we'll have to look at if they do want to build something else, but not today.
In order for anything else to happen, they've got the options. They can subdivide, they can come back to us. So doing this is just taking it back to where they need to be.
All right, I'm ready for a motion. No, ma'am, we've closed the floor. Ma'am, I've already called for that and I've closed the floor. I did call for opposition.
Several times.
I closed the floor. Board, what would you all like to do? We did call for opposition. As a matter of fact, Ryan put opposition up on the podium or on the overhead, read it. Board, I've closed the floor. Would you like to reopen and hear additional testimony?
I wouldn't have any opposition to reopening the floor.
Do it.
I wouldn't have any opposition to reopening the floor. I think it would be fine.
I'll take a motion.
Motion to reopen the floor.
Second.
Second.
Okay, we'll reopen. Ma'am, you'd like to come forward? We need to get her sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
State your name and address, please.
Lily, I'm at 4601 North Camden Lane. I'm on the access road, and my property is across the street.
Okay.
The purpose of deed restrictions is to ensure certain standards are maintained throughout the community and protect property values for homeowners. In the past 6 years, new homes, now valued between $500,000 and $750,000, have been built on all the surrounding lots within eyesight of the property in question at 4610 North Camden Lane. New homes at 4551, 4571, 4601, 4609, and 4617 were all planned and built by homeowners who followed code and built these homes as an investment. The value of the property at 4610 of $288,000 is not comparable to the surrounding home values. We oppose the proposed removal of the conditional use permit at 4610 North Camden Lane. The new owners purchased the property with the existing requirements in place. The burden is on the purchasers, the realtor, the real estate lawyer, to check these conditions with planning and zoning services to make sure they can meet the requirements of the land they purchased. We referenced our declaration of restrictions when building our home, prior to buying the property, and we kept a copy of it on files with our permits. We purchased our land in 2012. We had to save and plan for 5 years before building. We also could not afford the original plan that we hoped. We had to pay for new architecture plans and have our home built within reality. We purchased two sets of health plans. We had made sacrifices, and we asked no more of others than to abide by the same rules and regulations. I did contact Planning and Zoning Department 2 weeks prior to the sale of the property to voice our concerns and ask what the county would do to enforce these regulations. The county was aware of the sale taking place. I was informed that the previous owner, Mr. Rusnak, did contact Mr. Urban about the transaction. It is my understanding that Mr. Rusnak did not mention the adjustment against the property. Once I called the county and made them aware, I was told Mr. Rusnak was contacted and informed that he needed to notify the new owners before the sale. I am not sure what transpired between that call and September 2nd, the signing of the deed of conveyance at Stesson Associates. We can see in the signed contract on file with the county on page 3 where it states that the said estate is free and clear of all liens and encumbrances except for the 2022 state, county, and school taxes. In my opinion, being obligated to build a 3,600 square foot house residence is a burden, but that is between the Edwards and the Resnocks. It is not our burden as the local neighbors. While we feel badly for their predicament, we do not feel we should place our home and investment at risk because of a string of bad decisions. Speculation on land and building homes is risky. The prior owners of our land paid $100,000, and due to unforeseen obligations, we purchased it later at $82,000. I understand that it is a gamble anytime you build. To buy land that obviously doesn't have a house without a disclosure, realtors, or checking county planning would be risky. We were not aware of the 25% rural accessory dwelling for the ratio of their primary dwelling to the ADU. We do not believe any neighbor expected a 3,600 square foot house on the property. However, we do expect a comparably sized house and footprint to offset the oversized garage. Our primary concern with the property as it is would be in the event that the Edwards needed to sell the home. There is not much of a market for a garage with a 900 square foot home in it. And where does this place this property and neighbors in the future? We have no ill will or bad feelings towards the Edwards family. Their son plays with our children. He is welcome at our house. They are welcome. We were already concerned about the previous owners and building and their authenticity of building. We were hopeful that the new owners would be the solution that we were hoping for, and that someone who wanted to live there and build a home so the issue would be resolved. We feel that if the county had enforced the requirements when they were contacted by the original owners, we could have avoided this situation. We do ask that the Board of Adjustments and Appeals follow the law in this matter to avoid attorneys and litigation or further expenditures. Just to summarize, this all started with a request, a letter that we got in the mail because we were one of the original homeowners in that area. Since then, as I said, lots of new houses have been built. And I appreciate the words of in support of them, but that also happens to be the only owner that bought an existing house and did not build a home, did not follow the rules, did not have to save and abide by all the rules and the costs of those rules. It started with them sending a letter to the neighbors asking for support for the ADU. We signed off. We wrote a letter in support of them for the original Board of Adjustments decision. We were hopeful that they would build a house, have another family. We had the best of intentions and hopes for that. When it did not happen, and when we found out that they were selling, no one contacted us to say, we'd like to have this removed or we would like to change the plans. They reached out first when they wanted our original support, but nobody reached out with any intentions or plan of change. This was all done, and now they just want to remove it. My other concern is that, I don't know what the rules are for that plot of land, whether we all have the same regulations. But my own declaration of restrictions across the street specifically states that a full 2-story residence must have 1,000 square feet on the main floor. A 1-floor residence needs 1,200 square feet on the main floor. Bi-level 1,200, tri-level 1,500. A 900 square foot apartment does not even meet the basic requirements of a dwelling, primary or not. And so that is my concern. The neighbors would like to see a home on the property, something that in the event that it needs to be sold, it would be marketable and that we could have another family move in there. I understand they plan to live there forever. We all have plans that we hope, like I said, the previous people who owned my property planned to build and live there forever as well. We just can't live on promises. We would like to see a ruling that would end with some type of home there. And I'm not sure, I would like to ask a question back. I understand subdividing it. That was one of the things I had questioned, why if they needed to sell it, they didn't subdivide it. But what happens to the acre with the garage ADU on it if you do subdivide it and it's an acre of land by itself? Who's going to buy that, and what are you would still have the same thing. It's just a plot of land with a garage on it. So I'm not, would they be selling that and adjoining it to the property next to them that has a house on it? Or, it still kind of leaves us with the same issue that you would have a building with a 900 square foot apartment in it, which is not comparable for the homes in the surrounding area. And that's all I would like to say. Thank you for letting me come back up and speak. I do appreciate it.
Any questions?
I have a question. I don't quite understand the minimum square footage that you talked about. Is that
That's just on
Bill,
my,
Bill, are you asking about,
referenced square footage, and is that like a subdivision deed? I don't know what that is. I don't know what she's talking about.
restated declaration of restrictions. And when I bought my land, this is what I was given, that I told that if you buy land and you want to build on it, you have to meet these restrictions. I don't know what the restrictions are for the other side of the street.
That's the point. We don't know what those restrictions are, and if those were the restrictions, because Gretchen, you asked, were there any other restrictions, and we were told no.
yeah,
So I guess the other observation I'd have is I'd like to know what 4620 is, because it looks like there's a house sitting there on maybe half an acre, and it certainly doesn't, from my perspective.
That is a smaller home that has been there for decades, and that was, grandfathered in. The house on the right side was built in 1946.
Well,
At 4600. So most of those homes have all been there for quite some time. And what we're seeing, and the investment that we made, is that a lot of these homes are being, as homeowners move out or age on, they are tearing them down and building much nicer homes, which makes it the investment. When I moved in there, it was a trailer across the street. I bought that with the expectation of appreciation and as an investment.
Let me ask my question more clearly. So, are those subdivision deed restrictions, or are those county zoning regulations? Maybe Jim or somebody else could answer that.
so what she's referencing, these are the HOA deed restrictions. Yeah.
It's an HOA. I believe it was done, all of that area is principally done by minor plats. And somebody could, in transacting a minor plat or selling land, they created their own set of deed restrictions. So it's not really a homeowners association. It's just from the previous owner who might have placed these restrictions on it. It's not titled that way. I don't.
Regardless, it is restrictions that we do not have authority over, and this body does not judge upon.
Believe on this side of the street, the subject matter side of the street, there are any deed restrictions regarding size of houses. Now, up and down the street, maybe there are, but on this parcel, I don't think, we haven't seen that there are any. As a transfer of land from a previous owner to a new owner. Again, often when somebody sells land, they subdivide it even by minor plat, and that's what a lot of North Camden Lane has been, minor plats. The owner will say, listen, I want to make sure to protect my house or my property that there's some deed restrictions and you got to abide by them.
And again, whatever they are, this body doesn't have authority over those.
Okay, that was my question. Thank you.
Any other questions for, was it Leanne? Any other questions? Okay, thank you. So let's give the applicants time for rebuttal. Is there any other opposition? All right, let's give the applicants time for rebuttal if you'd like to come forward.
Regardless, this is our home. Regardless if it is 900 square feet and has the 2-car attached garage, this is our home. We live there with our child every single day. I do not think that we look bad to the community. I understand that it is a newer type of home and that some people may not understand that, but it is our home. We live there. And it was our understanding there is no restrictions to what we need to do.
Or any type of home that needs to be built. I mean, it is a up and coming type of home, like somebody said, a barn dominium style home. I mean, it's just on a smaller scale.
Okay. Questions? Rebuttal by, thank you. Rebuttal by opposition. Any final statements? Was this for opposition or I'm sorry. I've already called for that. I've already closed that. We're at finals. We're at rebuttals. We're done with rebuttals. Final statements. Opposition applicants. Any final statements? All right. Board members, questions for anybody?
No.
All right. I'm going to close the floor and open it up for discussion again.
Just to reiterate what we have learned for the purposes today, there is no deed restriction prohibiting the existence of a 900 square foot living space and a 900 square foot garage space on the lot at 4610 North Camden Lane. Is that correct? That's what we understand, correct? And that when this property came before this board in 2018, I believe it wasn't to get approval to build a certain square footage. It was to get an approval to build an accessory dwelling prior to a primary dwelling. That changed with it didn't get built. So on the transfer of property, the issue is not the square footage of the property. The issue had always been what was being built first and what was being built second. We're not ruling on what could possibly be built in the future. That would come before us later. So there is no deed restriction prohibiting the existence of this size house at 4610 North Camden Lane, is my understanding.
And even if there were, we do not have the authority to uphold those.
Correct.
I mean,
Agreed. I just want to clarify that so everybody's on the same page.
any other discussion? All right, I'm ready for a motion.
Motion to approve docket OC 23-010 for the removal of a previously issued conditional use permit OC 18-015 at the property located at 4610 North Camden Lane in Crestwood. The character and objectives of the proposed use and the potential impacts on the community and surroundings are appropriate. Potential conditions of approval. The conditional use permit shall only apply to the plan considered at the April 20th, 2023 Oldham County Board of Adjustments public hearing. And that is my motion.
Second,
Second.
any discussion? All in favor signify by saying aye.
Aye.
Those opposed? It's been approved.
Chairman, can I comment about one thing that's just relevant from the fact that when this came before this body in 18-015, there was no condition that would have required Mr. Rusnak to build a primary structure. You all didn't condition that approval. So, and the finding was actually that the accessory dwelling unit can stand on its own and could have been approved without coming to the board. So I'm just pointing out that you all had considered this. You haven't really changed the circumstances of anything. And if they want to come back and build an accessory dwelling unit at this point, or they want to build a primary structure and it's not going to meet the square footage requirement, they have to come back in front of this board. So,
All right, thank you. Okay, let's go on with the second. Gretchen, if you want to read the case, please.
OC 23-015, an application has been filed requesting a conditional use permit for a non-owner occupied short-term rental property located at 1706 Riverside Drive, Prospect.
Okay.
Ryan Fisher, Senior Planner, Oldham County Planning and Development. So this application has been filed requesting a conditional use permit for a non-owner occupied short-term rental property at 1706 Riverside Drive in Prospect. Site information, it is in a CO1 conservation area right along the river on 0.210 acres of land. No previous site history. Case history was posted to our website on the 29th of March. We sent out adjoining property owner notices on the 6th of April. And a public notice appeared in the Oldham Era on the 13th of April. Here is the property in question. It is not currently underwater, just for clarification purposes, but that is the property. And here is the conservation zoning district map. So the applicant is requesting a conditional use permit for a non-owner occupied short-term rental property. Section 250-050 item A in the definition states that a non-owner occupied short-term rental is the owner of the property that does not permanently reside in the short-term rental property or in the principal residential unit for which the short-term rental is associated with on the same lot. Once again, 250-050 item B number 2 states that they've got to come here for the conditional use permit. So we see these a lot, so you all should be fairly familiar with this. The submitted plans show a single-story 925 square foot structure with 2 bedrooms and 1 bathroom. And here are some pictures of the property that were taken, just to give you an idea of what we're looking at. So in summary, the applicant is requesting that conditional use permit for a non-owner occupied short-term rental at 1706 Riverside Drive in Prospect. Potential conditions of approval on this are the conditional use permit shall only apply to the application considered here at the April 20th, 2023 Oldham County Board of Adjustments public hearing. The applicant shall comply with all regulations concerning short-term rental properties outlined in Oldham County Zoning Regulations Section 250-050, and the applicant shall apply for and be issued a short-term rental property before renting the property. And with that, all that.
Ryan, would you roll back to the photo? We don't have those pictures. I'd like to see what. Then that's in existence now. That's been built. Yes. Okay.
And there were some pictures. I don't know if I included them with your staff packet. There were some appraisal photos that were attached. They weren't real clear in nature, but I guess this property used to have a deck on top of it and a stairwell. I think the applicants will be able to provide some detail as to the renovations they've done to the property. But this is what it currently looks like as of the other day on the 17th.
Okay, thank you.
Any other questions for Ryan? Ryan, just on Riverside Drive, do you know how many STRPs we have?
We dealt with this the last time we were on Riverside Drive, and I think there's 4 or 5. This is on the Oldham Acres side of Riverside Drive, so not the side of Riverside Drive we have previously dealt with, but this would probably be maybe the 5th. I would have to look that up, but I remember when we were here before, I think we'd said 4. So,
okay. All right, any other questions for Ryan? All right, thanks. And if we can have the applicants come forward. Raise your right hand, get sworn in, state your name and address.
Ahmed Fadil, address 1706 Riverside Drive.
You actually have to talk in that mic.
My name is Ahmed Fadil. Address is 1706 Riverside Drive, Prospect, Kentucky, 40059.
My name is Travis Turner. I'm the attorney for Mr. Fadil.
Raise your right hand.
Well, yeah, you don't have to be sworn in, but you do.
Solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Okay, thank you. And if you want to justify the project, tell us what it is you're trying to do.
We're here seeking a conditional use permit for the STRP. The property is subject to an HOA, Harmony Village Inc., which I believe is different than the other 4. The street is divided. Harmony Village was dissolved in 2012 and has only been brought back into good standing with the state in March of this year. However, the bylaws that are now active on that property have been in use for 30 years. The bylaws, just to be frank, are troublesome and troublesome for the county if the CUP would be denied. In fact, the gentleman to my left would likely not even be allowed to own the property.
Hang on, Travis.
This is in Oldham Acres, not in. They're 2 different subdivisions.
Understanding that this property is within Harmony Village. To the extent that the property is subject to Harmony Village's bylaws, they're problematic because initially this gentleman wouldn't even be allowed to own the property. I would direct the council's attention to paragraph 10, which says, none of the property in Harmony Village shall ever be sold or rented to or occupied by persons of African descent or anyone in those veins there is the slightest prescription of Negro blood, and no lot in Harmony Village shall ever be used for the sale or disposition of spirits, vinous, or malt liquors, and no chicken, dogs, or livestock will be allowed to roam at large in Harmony Village. And so, number one, clearly racist. Number two, as we described, there's already 4, for lack of a better term, Airbnbs on that street.
Mr. Chairman, didn't we encounter this a couple of months ago and we were directed this is unconstitutional and we were not to consider this because of the nature of this and in fact it was from 1947 and it's an inappropriate document to even be referred to.
Yeah, you are correct. We did hear a case here a couple of months ago. You're exactly right.
Why are we hearing it again? Why are we even considering this document?
Sir, I'm not aware of that prior hearing, so to the extent that the council has considered that, I do apologize, but in the interest of my client, I have a duty to bring up everything that would help.
Charlie, you are correct. Each case does stand on its own. This applicant was not aware or wasn't even present last time. This is their case. It's something completely different. That's why they're bringing it forward. You are correct that, well, number one, we don't have authority on HOAs or deed restrictions or anything outside the county's regulations. So everything that's in that document, albeit unconstitutional, we don't even have authority. It doesn't matter.
In other words, would it be the council's position that they don't have the authority to enforce anything that's in this?
The
Correct.
deed restrictions, that's right.
Indeed.
For several reasons, but
As I'm aware, but I just wanted to make clear. And so all of his permits are active. They've been pulled. The property is spotless. He's taken incredible care of it. In short, there's really no reason not to grant this CUP. As I said, there are several short-term rental properties on that street that have been granted. And so if you have any questions or to the extent you want to say something, I'll let him address anything else.
okay, thank you. Anything? Okay. Board members, questions for the applicants? All right, guys, thank you. May I take a seat? Is there anybody here wishing to speak in favor of the application? Yes, sir. Come forward. And state your name and address and be sworn in, please.
Hillary, 1312 Riverside Drive, Prospect, Kentucky, 40059.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes, sir. Speaking in support of the application.
I have a short-term rental, non-owner occupied on the street as well. Owned it for almost a year and a half. We've done a significant amount of work. Everything is very clean in the property. Having the short-term rental permit has allowed me to maintain the property, update it, and bring it up to all necessary codes. We're working with the county, with FEMA, in order to raise the property up, and I believe he's going to be working on major improvements as soon as his permit is approved with FEMA as well. All the short-term rentals on the street are permitted, and we all go to this court in order to seek proper approval prior to renting. That's why we're all here. But I have no opposition, and thank you very much.
Thank you, Daniel. Daniel, just out of curiosity, where in relation to the applicant's home is yours?
Located approximately 30 houses upriver.
All right, thank you. Any other questions for Daniel?
Similar in scope, similar in size, 2-bedroom, 1-bath property.
Okay, thank you.
Very much.
All right. Any other support? Opposition? Anybody here wishing to speak in opposition? Yes, ma'am. I'll ask Ryan about letters in support and opposition after you speak. Go ahead. Okay. All right, Ryan, come on.
All right, so I'm guessing this is Miss Barker. Yeah, so I spoke with her on the phone. She did send me an email letter on Monday, April 17th. So what it says is this: thank you so much for speaking with me about the proposed conditional use permit for 1706 Riverside Drive on Friday. My family owns 1704 Riverside Drive, and we are opposed to approval for a CUP for short-term rental. We prefer not to have different transient people coming and going from our neighborhood. This is a quiet, tight-knit, neighborly community that have established themselves for a long time and prefer to keep it as such. I feel that other neighbors should have been notified of this proposal, not just adjoining property owners, as I am sure they would be opposed as well. I also feel that there should be a distance requirement in Oldham County between short-term rentals, as there are already 2 on Riverside Drive. The property at 1706 is a single-story grandfathered property as far as height requirements of the structure due to flooding issues. The space that will be occupied has been flooded every time the river has risen to flood stage. The structure could have mold issues, and I am unsure of the state of the septic system for the property, as the property has not been kept up for many, many years. There is also a safety issue as far as the decking that washed away and is now an open pit on the back river side of the house. We also do not want potential short-term renters to access our property at 1704 for recreational use, as it is a park-like setting with a picnic table and seating and is private property for our family and our guests only. Obviously, in conclusion, we are opposed to this CUP for a short-term temporary housing opportunity for traveling community service workers at 1706 Riverside Drive. We do not feel this is a good fit for our neighborhood and hope the CUP is denied. Thank you for the opportunity to voice our opposition. Sincerely, Barbara Barker.
While you're up, were there any other letters of support or opposition?
No, sir.
Okay, thank you. Yeah, that's correct. I need you to be sworn in and state your name and address.
Barker, 1704 Riverside Drive.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay.
My main concern is safety. People coming and going. I'm not sure how long they're going to come and rent that. Is it going to be a month? Is it going to be a day? Is it going to be a weekend? So I'm concerned just for strangers, people coming to the neighborhood, that we're there enjoying our property. We don't know who these people are, so.
Speak to the mic, please.
So for me, it's a safety issue, who's coming and going. We don't want people just wandering over onto our property. So that would have to be something that, is clarified when, I think I changed the picture. Nice. But anyway, that's really my main issue, is that just random people are coming and going. So, like I said, I don't know how long somebody's going to be there. Is it going to be a day, a weekend, 3 months? So that's just my concern.
Any questions for Barbara? Good. Thank you, Barbara.
Something that would be addressed is like the septic and whatnot before it's approved, or not necessarily.
They have to get planning and zoning. They have to comply with all the planning and zoning regulations. So.
All right. Like I said, I'm the only one because nobody else is notified, but.
Okay. Thank you. Any other opposition? All right. Time for rebuttal.
That Ms. Parker would like to see some sort of distance requirement between short-term rental properties. This is not the proper forum for that, obviously. She's welcome to advocate for that with the legislature or proper rulemaking authority. To the extent, as you mentioned, she's worried about the septic tanks and things like that. Obviously, we have laws in place for a reason. You would have to comply with all of the zoning requirements, as you said. And then as far as her concerns with respect to transient folks coming and going, how long they're going to be there, I mean, if someone was going to buy the property, for example, no one has to complete a survey to state how long they intend on living there. Secondarily speaking, there's no evidence, she's presented no evidence that there would be any, for example, violence at the property or anything of that nature. People who rent properties are not of a special group that are predisposed towards violence. There's no studies on that. In fact, the FBI would suggest that, and pretty much all of law enforcement would suggest, that crime is overwhelmingly committed by people that you know personally. And so, as to the extent that you would place weight on her concerns, it shouldn't be much. And so, that's all I have. Thank you.
Thank you. Questions?
Mentioned that there was some dilapidation, that there was something in the back of the property or something fallen into the back of the property. I didn't really catch all that. Is that something that we're not seeing in these photos?
I'm personally not aware of any deck that's been, I guess, washed away, if you want to address that.
There was a deck that was built on top and then was removed. But as far as I know, there's nothing in the back that's causing any safety issues.
Okay. Thank you, guys. Rebuttal from the opposition. Do you have any rebuttal? Yes, ma'am. Wait till you get up to the mic.
I don't have a lawyer or anything, but I mean, I have a right to speak my opinion and how I feel. So there is an empty hole behind there that is not shown. Once you walk out the back door, But I mean, I'm sure he'll fix it up, and that's great and fine. But I'm just saying, I'm leery and unsure.
Okay. All right. All right. Any other final statements? Board members, questions for anybody?
I have a question. So the materials we have here shows the property at 1706 Riverside, and the picture we have in front of us is 1704 Riverside. I'm not sure what I'm looking at here.
To that for you. So when I send our code enforcement gentleman out to take photos for me so that I don't have to leave the office, on his phone he has a program when he takes these pictures and it goes off his GPS location. So he was standing in front of 1704 Riverside Drive looking at it. So when he sends me these photos, because I had the same question to him the first time he sent it to me, I said, you went to the wrong place. So that's what it is.
Okay, thank you.
Jim?
I just have a couple of things. It's typical for you all to ask questions about things like security cameras. You heard that there's a neighbor concern for security. You didn't ask any of those questions. You may want to consider it. I'd like to make sure and add a condition of approval to this, that any expansion of the existing structure must comply with the FEMA, NFIP, and the Oldham County flood hazard ordinances. We've had folks who have gone and started doing renovations and things on their buildings without putting in flood vents or making sure that the living space was elevated. Just want to make that a binding element, a condition of approval.
I saw you look at your paper when you said that. Yeah, did you write that down? Is it something that you can give to, you can give that to Gretchen, please? And thank you for reminding me of the cameras and noise. And I would like to call the applicants forward again. And if you can address noise and cameras.
To the extent there's concerns with respect to security, Empire Realty has placed security cameras around the property. In fact, there was a break-in where tools were stolen, which prompted the imposition of those security cameras. With respect to the noise, go ahead and address that.
I'm sorry, what was the concern about the noise?
Limiting the noise, policing the noise. So oftentimes we do set conditions of approval. And to be honest, I don't know what these things are, but it is noise monitoring and regulating devices that the owner would be notified if noise exceeds a certain level. And
the security cameras that you have, they go to your phone. You can see them. You get notified whether there's motion and excessive noise. Right?
Yes, I get alert notifications.
And to the extent that you would be renting the property out as an Airbnb, within those contracts, you would have provisions that regulate the noise. Is that right?
Yes, that's correct. It's in the contract that there is no loud music, no party is allowed. It's in the...
Either like quiet times, that no parties beyond a certain point or too early in the morning or anything.
I believe in those contracts you say there's no parties allowed, period. Is that right?
Yeah, it's usually written in the contract when they sign to rent out the property.
all right, questions for the applicants?
Would just say that to the extent that the board would feel more comfortable passing or asking for conditions in order to grant the CUP, given that Empire Realty has those conditions already generally written into the contract, there's going to be no objection from us with respect to having a special provision saying, hey, no parties past, for example, like 9 or 10 p.m. or if it's a weekday related, anything like that, especially with respect to security.
Okay, thank you. Any other questions? All right, guys, you can take a seat. Guys, I'm questioning the noise. What are these devices and how are they used? Do you all know?
I have a specific understanding of a particular brand or type of device, but I know there are exterior cameras that also can monitor noise. And that's, I think, one of the key things is that since this is a non-owner occupied short-term rental, and the requirement in the short-term rental regulations is that a responsible person be within 25 miles, it's helpful when somebody's watching to make sure for the protection of the neighbors that there aren't activities going on outdoors that would be disruptive to the neighborhood. So in the past, people have volunteered. They've said, we're putting out cameras on the building, and they've talked about these devices. I don't know what they are.
Okay.
Yep.
And how have we stated that in the past or regulated that? And again, I'm talking specifically noise, or even have we?
Remember, do you have, I don't know if that was a binding element or, I mean,
Or maybe it's we do exactly what you were referring to is, after a certain period of time, there's no loud music, loud noise after.
We've dealt with that with party venues. But other than that, I don't think we've.
On the party venues, there was a device that rated decibels, and then if it went above a specifically set decibel, it sent a notification to the owner. That
Not
I
on
don't know
rentals.
that we made that a stipulation. I think that was something they presented.
that's something where we've conditioned it, or does it say something?
No, I was just going to say, I mean, I've seen it both ways. We've seen it where the applicant has stated they would have cameras and limit the noise based off of, like the applicant stated, based off what their contracts say. And then we've also had, where nothing after 10 p.m., but a lot of times those are with
The event venues, yeah.
have event venues with short-term rentals. And it's that way.
Right.
Does the county have short-term rental regulations and rules that we can incorporate by reference here, or should we suggest to somebody that those rules get amended or enhanced with respect to noise and cameras and things like that?
The condition of approval, if you're considering approving these, that we always say that they have to apply for a short-term rental application. This is a conditional use. That's one step. The next step is actually come in and make an application. That application has things like floor plans to show where exits are, and it has a checklist items, including who's going to be the responsible party. So that's taken care of. To add something regarding cameras is just simply adding a condition of approval. I really don't think that the regulations need to be amended. I think you just do that here.
But here,
as a condition.
okay.
All right. Where was I? Any questions? Okay. All right. Anything before I close the floor? All right. I'm going to close the floor for public opinion and open it up for general discussion.
I think this application's in line with other applications that we've seen for this area. And, I mean, according to the testimony that we've heard from opposition, this was a property that was falling into disarray. And this is an opportunity for that to be corrected. A lot of times when we see these properties becoming short-term rentals, there's an investment put into them to improve the condition of the property.
So what is your all's thought on the cameras and as far as a condition of approval? What is your all's thought on putting a condition in there for the place to be monitored and regulated for noise and activity?
I would support that. I think it would be helpful, especially in an area like this where there's other neighbors that may have issues with noise and that type of thing. So,
how do we word that?
Well, it would have to go into the contract that someone would fill out I'm assuming it's going to be advertised on things like Airbnb and things like that. It would have to be included in the contract that someone signs, that they would have to comply with, say, a specific quiet time or, but then the security camera issue, we would have to address directly in the conditions of approval.
The applicant's already said that
Okay.
that they A, have the security cameras, and B, that there's wording that they monitor. So I think if we keep it generic enough and just say that the subject property is monitored and regulated. I don't know.
during any short-term rental. I mean, what I've experienced where they unsubscribe from the monitoring service, and so then it's not continuously monitored. So, yeah.
So then what do we put in there?
During any short-term rental, that the property will be monitored for security and for noise. That's that.
Property is monitored for security and noise.
Got it.
Any other discussion? All right, if not, I'm ready for a motion.
Okay. Motion to approve OC 23-015 for the application requesting a conditional use permit for a non-owner occupied short-term rental property located at 1706 Riverside Drive in Prospect. The characters and objective of the proposed use and the potential impact on the community and the surroundings are appropriate. The proposed use is compatible with surrounding land uses and the general character of the area. Potential conditions of approval. The conditional use permit shall only apply to the application considered at the April 20th, 2023 Oldham County Board of Adjustments hearing. The application shall comply with all regulations concerning short-term rental properties outlined in the Oldham County Zoning Regulations Section 250-050. The application shall apply for and be issued the applicant shall apply for and be issued a short-term rental property permit before renting the property. Any expansion of the existing structure must comply with FEMA NFIP and Oldham County and flood hazard ordinances. The property shall be monitored for security and noise and regulated by the property owner during any short-term rentals. And that is my motion.
Thank you. Do I have a second?
Second.
Discussion? All in favor signify by saying aye.
Aye.
Aye. Those opposed? Been approved. In minutes. Did everybody receive the minutes? Did anybody have any adjustments? Okay, can I get a motion?
Motion to approve the minutes.
Can I get a second?
Second.
Discussion? All in favor signify by saying aye.
Aye.
Those opposed? Minutes have been approved. Any other business?
Just want to tell you, next meeting, May 18th, we do have items already on the docket, so plan to be here.
Very good.
Thank you.
Anything else? I need a motion to adjourn.
To adjourn?
Second.
Discussion? All in favor signify by saying aye. Aye. Those opposed? Meeting adjourned.